So I want to thank everybody for coming tonight. My name is Patty Schramm. I'm the Parent Resource Coordinator Trainer for the SALT series, the SALT Talks program. And I just want to welcome everybody here tonight. We will be hearing tonight understanding guardianship and who is APSI. I just thought it was great to bring in APSI because I know as a parent, I haven't as a parent, I didn't know about APSI, and I thought it's another service that's out there that is a great service for parents to tap into. We have Kristina Gaible here from APSI, and I'll let her take it from here. See, I made you co-host so you can share your screen.
Okay,
Kristina,
great.
And I'll turn it over to you.
All right. Hello, everyone. As Patty said, I'm Kristina Gaible. I am the Regional Program Director for Southwest Ohio for Advocacy and Protective Services, Inc., also known as APSI. So I am here today to talk a little bit about guardianship, alternatives to guardianship, and a little bit about APSI as well. I'm going to go ahead and share my screen with my PowerPoint, so I won't be able to see everyone on the screen, but as Patty mentioned, please feel free to type any questions you may have into the chat. All right. So a little bit about what APSI is. I saw on the poll that a number of people had no idea who APSI is, and that does not surprise me. But APSI is a guardianship agency here in the state of Ohio. We represent adults with developmental disabilities. We are actually mandated to exist under Ohio Revised Code, and we are actually contracted to the Ohio Department of Developmental Disabilities to render this service. We are a nonprofit agency, and so our services don't come at any cost for the individuals we serve. Statewide, right now, APSI represents in guardianship about 3,500 individuals in all 88 counties. As I mentioned a minute ago, I am with the Southwest region, so I am the regional director for the lower 16 counties here in Southwest Ohio. My region goes from the northern part of Logan, Shelby, and Darke County down to the Ohio River of Hamilton, Claremont, and Brown, and kind of everything in between those counties. So I saw on the poll, the majority of you attending are from one of the counties that I operate and serve within. There was a few outside of my region, but APSI does serve in those counties as well. Predominantly, the services that APSI renders for individuals is guardianship, and we do offer a few other services. We also have been diving into supported decision-making, as well as we offer trusteeships and conservatorships as well. So it's a little bit about APSI. Now, APSI, while we exist statewide, we're not the only entity out there that does guardianship for adults with developmental disabilities or guardianship in general. Some areas of the state have volunteer guardianship programs. There are other agency guardianships out there that are not under contract with the state or the Department of Developmental Disabilities, but that do just the same kind of services that we do as well. So I'm happy to elaborate on options that may exist in your counties if you have a specific question about alternatives to us as well. As far as what we're going to cover in this presentation, we're going to be looking at topics that we're going to cover are going to be who needs a guardian and who would benefit from a guardian, what kind of guardianships are there, the different categories, some challenges you may face being a guardian, and then I'm going to touch some on some of the alternatives that can be explored to guardianship. So first and foremost, one of the questions that I often get asked when I get calls from county board employees, providers, family members is who needs a guardian? You know, how can we determine if there's a guardian that's, guardianship's needed? And there are some basic questions you can kind of ask yourself about your loved one. And some of the questions that you might want to ask about your loved one is, do they understand the decisions that they're making? You know, are there supports that may help them understand the decisions they're making outside guardianship? If so, then that's great. Another question you can ask is, does the individual have an understanding of how to make decisions? If not, do they have supports within their circle of supports that can help them understand the decisions they're making? Can the individual communicate their decisions with their appropriate parties? And if so, do the other parties understand what they're communicating? Do they understand the consequences of their decisions? You know, we don't often have to like the decisions sometimes that are made by our loved ones, but you know, if they understand the consequences of those decisions, that's a big factor there. If you're answering no to any of those questions in regards to, do they understand the decisions? Are they capable of making their own decisions? Can they communicate appropriately? Do they understand the consequences? If the answer is no, then guardianship may be needed. But if the answer is yes to all or any of these, then a less restrictive option may be able to support the individual better. Guardianship may still be needed, but maybe not as a full scope of a guardian as a guardian a person. So kind of continue on that, who needs a guardian? Often individuals who have more profound issues, who clearly do not understand a request for consent and cannot provide informed consent, would benefit from guardianship. And also in situations where a guardian's decision can have a really significant impact on the individual's life or their outcome in a situation. Individuals who may not need a guardian, those that are very clearly able to understand the questions and the requests being made of them, those that understand the negative consequences yet still choose to make those decisions, and individuals who are not going to necessarily obey the decision of the guardian. And I use the term obey because as a guardian, you can make decisions, you can select services, you can provide consent, but you can't force someone to comply with the decisions you're making. Guardianship always requires a little bit of a give and take between the person under guardianship and the guardian themselves. So I kind of want to break in a little bit about the different types of guardianship. A lot of times people hear guardianship and they assume it's all encompassing, but there are actually a lot of different variations here in Ohio on the scope of guardianship. So the types we're going to be reviewing real quick are guardian of person, also known as full guardianship, emergency guardianship, successor guardianship, limited guardianship, interim guardianship, guardian of estate, and guardian ad litem. So guardian of person is the most common type of guardianship here in the state of Ohio, and pretty much probably around the US as well. Basically what this is guardianship that allows for a guardian to have authority over the decision making and consent for areas such as residential placement, medical treatment, behavior supports, services and supports that the individual may need. A guardian of person has no authority over financial matters. So we can't sign leases, we can't sign benefits, we can't sign contracts for the individual, but we can authorize someone to do that for the individual. So we do have the capacity to authorize a payee. We do have the authority to authorize an authorized representative who can manage the benefits for the individual, but we ourselves can't do that. So basically, when a guardian of person is established, what is occurring in the probate court side of things is the individual has been deemed incompetent, meaning that they lack the capacity to make the decisions in certain areas or all areas of their life. When that occurs and they're deemed incompetent, they need someone to help make those decisions. However, there are areas that a guardian aren't going to be making decisions on. individuals still retain rights to make some decisions for themselves, especially in areas that are not contrary to the authority of the guardian. So a good example of this would be your loved one wants to go get a tattoo, or wants to dye their hair, or has decided that they want to go to this movie and not that movie, or they want to other daily activities that they want to elect to choose for themselves. They have that right to do so. Later on, I'm going to talk a little bit about some other rights that they do retain regardless of guardianship, but I'll elaborate on that a little bit further. But there are other rights they retain, including like the right to vote and other services as well. Another thing that's clearly outlined in Ohio law is that individuals with a guardian still have the right to participate in the decisions that impact their lives. It's something as a guardian we need to be taking into account for is what are our individuals and our loved ones' thoughts on the matter, and how can we best represent what their interests are while still ensuring their needs are being met. Another type of guardianship is a limited guardianship, and this is a less restrictive option than a full guardian or a guardian of person. What this is essentially the individual gets declared incompetent in only one part of their life instead of multiple parts. So a good example of this is maybe the individual makes really good decisions in regards to the place they want to live. Maybe they do a really good job of connecting themselves with the right services and supports. But maybe the area where they really lack an ability to really understand is medical. Maybe they have a lot of medical things going on, and I don't know about you, but medical jargon can get a little heady, and talking to doctors can be cumbersome. So it is not out of the realm of possibility that sometimes individuals who are very capable of living their life struggle in areas of like medical and medical consent. So it's possible that they get declared incompetent for medical only. So if you're someone who has a limited guardianship of someone, your capacity is only over that limited scope. You would have no authority over placement or services if you're only over, for example, medical. Guardian of estate. I'm not going to spend a ton of time on this. The long and short of what I want you to take away from a guardian of estate is a couple things. The probate court is going to be the one that determines if the individual themselves lacks the capacity to manage the finances. A guardian of estate is designed to help receive and distribute funds and manage property on behalf of the individual. One thing I'm going to say, though, is if you're looking at doing a guardian of estate for one of your loved ones, I would strongly urge you to find a local attorney who understands guardianship of the estate to help you walk through the intricacies of this role. Guardian of person and guardian of estate are very different in how they roll out. With a guardian of person, you basically are issued a letter of guardianship and you go do your job. A guardian of estate, you're issued a letter of guardianship, but you can't act on any way, shape, or form, and you can't distribute funds or receive funds or make any changes to the person's finances without court approval on each and every step. So having an attorney that can help you navigate the ins and outs of a guardian of estate is a smart play. That way you're not going to get called into the court because you forgot to file something about assets. So if you have questions on guardian of estate, I'm happy to answer them later. But I would, again, the thing to take away from it, guardian of estate, find a local attorney who knows what they're doing in that front to help you.
Kristina, there is a question out there while you're on that. It says,
Yeah.
Can you explain the difference between guardian of estate and power of attorney?
Sure. So guardian of estate has the ability to enter into contracts on behalf of an individual. They have the ability to sell assets and property, whether it be cars, real estate, or any other asset of worth. And guardian of estate is usually established for individuals that have financial capabilities or financial needs that exceed usually around the $20,000 mark. So if you have someone who had an inheritance and they have a large estate that needs to be managed on their behalf, or has an income coming in where, you know, they need to be dispersed that's beyond Social Security and just regular wages. So power of attorney, which I'm actually going to get into a little bit later, a little bit more in depth, but power of attorney is literally designed for an individual to step in only when that individual becomes incapacitated. A power of attorney is not a, you know, give all, be all, pass to make decisions for an individual if that person that issued that power of attorney has the capacity to make those decisions. So a power of attorney, think of it like this. A power of attorney, a medical power of attorney would be situations of an individual's in the hospital, they're on a vent, they can't make their own decisions. So the power of attorney would step in and act until that person was conscious and able to make their own decisions, at which point in time the power of attorney wouldn't have any authority. The individual would resume their own decision-making capacity. Financial power of attorney is very similar as well. Like a personal example, I moved out of the country for several years. And so in order for any kind of financial issues that might arise where, you know, a loved one may have to go in person to address it on my behalf, I set up a power of attorney. But they could only execute it because I was incapable at that point in time to be in person to address a financial issue. Once I moved back to the US, that power of attorney became moot because I was then able to resume any kind of financial issue, address any kind of financial issues I had in person. So again, power of attorney is only very limited in scope and only effective when the person themselves that granted it lacks the capacity to act on their own behalf. A guardian of a state and or a guardian of person, there is no, you know, in and out capacity issue. You've been deemed incompetent, and that person, you have the authority to act regardless, essentially. Hopefully that answered that question. Okay, other guardianship options. I often get calls at APSI saying, hey, we need an emergency guardian, you know, can you help us out? There's a difference between needing a guardian quickly and needing an emergency guardian. Emergency guardianship under court terms is basically saying that there is a significant issue of health and safety impacting an individual, and a guardian needs to be put in place immediately. Emergency guardianship is only good for 72 hours. It can be extended for up to 30 days, but it is not designed to be a long-term solution. It's designed to step in, address the issue, and step out. APSI's been called in for some emergency cases. Most of the time they're medical related, where an individual who normally is able to make their own decisions doesn't have a power of attorney, ends up in the hospital on a ventilator. They need someone to step in, make some decisions on the medical care for the individual. And once that's been addressed, then we've stepped back out. Successor guardianship is another type of guardianship you may hear about. Basically, it's really simple. It's when one guardian steps in and takes over guardianship for another guardian. There's already an established guardianship case, and we're just transferring who's in charge, essentially. Interim guardianship is something where the court can appoint someone to act in that role. And a good example when this occurs is when one guardian resigns, but there's not a new applicant or a new guardian to take over immediately. They may call and appoint, you know, APSI or a local attorney to just act as interim until they find someone permanently to take it on. And guardian ad litem is something that occasionally you'll hear as well. A guardian ad litem is appointed by the probate courts, basically to look out for the individual's best interest. It is possible for an individual to have a guardian and a guardian ad litem. A guardian ad litem is not going to be making the decisions for the individual, so to speak. They're there to make sure the individual's interests are being represented correctly and report any issues to the court, essentially. So what is the role of the guardian? That's kind of a broad question, but to narrow it down into some very basics, your role is to provide informed consent, whether it's for medical care, for services and supports, for placement, whatever the scope of your guardianship is for, that's what your scope for consent is. We're there to help provide support and be an advocate for the individuals who need it. We're there to help our loved ones exercise their individual rights. We're there to help assist making sure that their wants and needs are known. We are supposed to be there as a support and a positive communication to help build relationships with families and friends that they may have. I know most of you guys are the family and friends of the loved ones, but here at APSI, we're not the case. We're a professional guardianship agency, so part of my job is to make sure that my individuals have the ability to connect with their families and friends in a safe way, to build new friends out in the community in safe ways, and be a positive influence in that capacity. And here in Ohio, we also have to comply with probate court rules. Each probate court has their own set of local rules. And then here in Ohio, we have the Supreme Court of Ohio's Rule 66 and it's the superintendent's rule overseeing guardianship. It is a handout I sent Patty, so I believe she has that to share with you guys. Rule 66 encompasses a ton of information, but the big takeaways from that, it really dictates what your role and what you're responsible for doing as a guardian. Some of the big things include you must visit with your individual at least 4 times a year. Being the fact that most of you are family and friends, that's not going to be an issue. You are required to notify the court in advance by at least 10 days of any upcoming move of your loved one. The court must approve those moves in advance. You're required to file annual reports with the court, and an annual report is very much just basic demographic of, what's your individual been up to and how are they doing throughout the year. You're also required to notify the court of any significant MUI, major unusual incident that involved your loved one. So there's a number of other requirements to go with it. As I mentioned, Patty has the handout. I would strongly encourage you reading those 12 pages. Not everything in that is going to apply to every single guardian, because again, they try to encapsulate guardian of person as well as guardian of estate and other types of guardianship as well. So you'll just have to pick what it actually applies to you and the type of guardianship you're establishing for your loved one. When it comes to decision making, there are a number of challenges that you'll face as a guardian. One is what I like to call is the best interest principle. It's how we make decisions. You're often going to be faced with a lot of challenges trying to figure out, what do? Your individual wants to do this, but you don't think it's safe. You have health and safety concerns about, concerned about the outcome something could occur. You're going to want to always try to make the least intrusive, the most normalizing, and the least restrictive decision possible. Not always easy, though. One thing you do want to do when you're trying to make decisions on behalf of your loved one is take into consideration their current and their previous wishes. You're not always going to be able to follow them. There's going to be times that you have to make really tough decisions that may be contrary to their wants, what their wants are. But hopefully through communication with your loved one and your individual that you have guardianship of, eventually everything will pan out okay. You also have a responsibility to the superior guardian. And in this case, the superior guardian is the probate court. The probate court says that you are responsible for the health and safety and protection of your individual from harm. And you have accountability to them under Rule 66, which I mentioned just a bit ago, on what kind of filings and reports that you have to give them. Now, probate court rules and rules that exist under Ohio Revised Code have some antiquated language at times. They use the term ward. In a number of cases, they still use the term mental retardation instead of intellectual or developmental disabilities. So the probate court views what a guardian should do very differently than a lot of external systems like DODD or mental health or any other just social service system views how we would serve our individual. In fact, the probate court and Ohio Revised Code says it's our responsibility to protect and control our ward. I don't know about you, but I cannot control any of my individuals. They're going to listen to me or they're not. We really truly as a guardian lack the ability to control their actions. We cannot be a policing function. That is not your role as a guardian, and you can't make an individual do something. I have attended court hearings where they said, well, just make them take their meds. Great. And I've always thought, how do you want me to do that? Do you want me to force the meds down their throat through a tunnel, through a funnel or something? What do you want me to do? You can't physically do it. On paper, it reads one way. The practicality of it and actually implementing it in person is very different. Another area where there's pretty big decision-making challenges, and this may not apply to everyone or anyone on this call, but if your loved one makes really poor decisions and you have guardianship and they end up involved with law enforcement, just know criminal trumps probate every day of the week. What that means is, as a guardian, we have very, very limited authority on anything to do with criminal matters. Basically, the thing we can do is advocate that they get the right representation, that they get a public defender if need one, that they get evaluations to determine their competency, which would basically be, do they understand what they're doing? Can they participate in their own legal defense and those type of questions? But we can't stop criminal charges from occurring, and we can't prevent criminal activities from occurring. As I mentioned just a minute ago, the term competency eval, I want to highlight the fact that competency evals in criminal court are very different than competency determinations in probate. Just because you're determined incompetent in probate court does not mean that you are incompetent in a criminal court. They have two very different outlooks, and they're determining two very different things. Probate court competency is looking at long-term inability to manage one's life. Criminal court competency is looking at momentary, situational, did they understand what they were doing? And if so, can they participate in their own legal defense? Can they work with their attorneys to create their own defense? Two very different things. I wanted to also highlight a little bit about the communication system with DD and the probate courts. I thought the best way to do this is through just this little simple graphic that I put together. The individual's very much in the center. Surrounding them is their support team. It's providers, the guardian and or family members, the county board of DD. Off to one side, you have the department of DD, and on the other side, you have the probate court. And you can see on either side, DODD and the probate court don't really talk to each other. One of the other challenges you're going to face as a guardian and you operate within these two systems is that you have the probate court's requirements, and then you have DODD's rules and regs, and sometimes they do not mesh. And so that kind of goes back to that best interest principle and just really trying to make the best decision you possibly can for the one you serve and for your loved one.
There was a question on the chat that said, is the guardian liable? Is the guardian legally liable for the loved one? For example, if a are the guardian's assets at stake if the loved one causes car damage, there's damage, car accidents and such.
You know what? That's a great question. I'm going to answer it. It's not a simple yes or no, but largely no. The only way you would be liable is if you knowingly handed them that rock that they were throwing at that car. Or if your loved one decided to steal the car, if you knowingly left out your keys knowing that they would grab it or handed the keys yourself to them, you might be liable. but that's about the only time you would be actually liable. As a guardian, you're not liable for your individual's actions unless you knowingly expected it to occur and or helped them participate in it, whatever action they did that violated the law or created a lawsuit. So hopefully that answers that. There is no actual liability where you could be sued legally because your individual took an action unbeknownst to you or without knowledge, without your knowledge. There's no laws in the book that allow that to occur. Now, I'm not going to say that there's not someone out there that might try to file a frivolous lawsuit. They may. You might get tossed up in some kind of a court hearing, but there are no laws in the books that allow for the guardian to be liable, especially if they have no knowledge of the actions of their individual.
Looks like there's another question here, Kristina.
Great. Yeah.
About APSI. When APSI is guardian, is it anyone that is qualified at the agency, or are individuals assigned to people?
Okay, that's a great question. So APSI, since we are a nonprofit professional guardian, we have protective service representatives that operate as the guardian rep for individuals. However, it's the agency that's guardian. So the nice thing about APSI is anyone at APSI can provide informed consent at any time for any individual we serve. But they may have a designated rep that's their day-to-day point person for all services, follow-up, visits, whatever may be going on with the client. And that rep knows them the best. And that's something that until very, very recently, most other guardianship entities out there couldn't do. For a long time, up until actually this year, the only agency or company that was allowed to be listed on the letter of guardianship as an agency was APSI. Just recently this year, the law changed and they've opened it up so agencies like Life Essentials or Lifespan or Personal Guardianship Services, some of these other corporate professional guardianship entities can now be listed just by their name as well, which is really great because essentially what would happen before is anytime they were appointed as guardian, it would be specific individuals or staff that were appointed versus the agency themselves. And anytime someone would leave that agency, they had to go back to court and get it all changed up and get all the paperwork straightened out. And it was kind of a mess. So I'm kind of really glad that that's occurred for them. But at APSI, it's the agency that's the guardian. And we have a wonderful 24/7 on-call team that helps man, any kind of emergency, medical or otherwise after hours. So hopefully that helps answer that question.
And there was a question that asked, is there a waiting list at APSI?
Yeah, another good one. Okay, so yes and no. There was a waiting list put in place back in 2010. The waiting list still technically exists. However, at this point in time, we're really not putting a whole lot of new people on it. We're very much treating intakes and referrals based on the view of emergent need. If there's truly an emergent need for an individual to have a guardian, then we're going to figure out a way to serve them. So we have a great, wonderful referral process. I'm happy to talk, specifically with anybody on the chat that wants to talk about that after this presentation, a little bit more about in depth how that works. But there was a waiting list. There technically still is a waiting list, but we're really not adding anyone new. We're really trying to figure out how to serve individuals that truly need it as they come through. Okay. Rights of the ward. I mentioned a little bit ago that there was additional rights that the individual held, and these are some of them. Obviously, I think a lot of people on this call are very familiar or have at least heard of the DD Bill of Rights. It is part of Ohio Administrative Code. The DD system has done a great job of really making a lot of people aware of the rights of individuals. They retain all those rights within that list. Now, one thing I want to also highlight is that as a guardian, those rights transfer onto you as well. So you have the ability to help interject if your individual is making a really poor decision, even if it's their right to do so. You have the ability to still act and try to help facilitate success or address any real safety concern that might come as a result. One area individuals also retain the right is reproductive rights. I have no authority to tell my individual if they can or cannot have sex. I also have no authority to approve abortions or sterilizations. I have no authority to address sexuality and when it comes to sex changes or any kind of LGBTQT dynamics. So if there's ever a situation where any of those situations arise, it really needs to be brought before the probate court as superior guardian to make the ultimate decision. You as the appointed guardian really don't have any legal authority to make those decisions without the probate court backing you up. Another area individuals retain rights is voting. They have the fundamental right to vote. They have the right to ask for help in their voting as well. They have the right to serve on a jury. They also have the right to execute a will, and they can also execute a power of attorney. Now, executing a will and executing a power of attorney when there's already an established guardian, it's something that there would have to be some assessments done to determine if they actually have the capacity to do so. And if they do, then great, they can do that. The probate court would likely be involved in those discussions as well. And under Rule 66, some other rights that were kind of reintroduced or given to the individuals is the right to drive and also to marry. The right to marry was a big one under Rule 66 because technically when you're married, your spouse kind of becomes your natural guardian, default guardian, your consenting agency. You know, they're the ones that provide consent for you if you become incapacitated. So if there's a guardian and a spouse, then who has that right? So ultimately, it doesn't really matter because the probate court's going to have to weigh in on the marriage anyways. The probate courts are the one that issue the marriage licenses. So if there's a guardianship and an individual goes to apply for a marriage license, it's likely going to flag with the probate court, and the judge over that case will likely hear the request to determine whether or not an individual can actually marry and has the capacity to marry and help make the determination, does the guardianship remain or does the spouse take over in that role?
What if both individuals have guardians?
And that's very possible. Yep. We have seen that before. And then it would be the probate courts that would have to determine, do both guardians still stay in place for their respective loved ones? And then the individuals, they'll just have that right to marry, you know, and they have the right to live their life together as husband and wife or spouses, you know, whatever, regardless of, you know, sexual orientation, they have that right. So again, the probate court would delineate the very specific situations on that, and there would be new orders issued under both guardianship cases if that was the case. Okay, so a little bit about some alternatives to guardianship. I'm going to kind of review with you some less restrictive options, both in the financial as well as just general support realm. We're going to touch base a little bit about representative payee and authorized rep, the stable and able trust funds, conservatorships, power of attorneys, protection orders, adult protective services, and other community resources, and then supported decision-making as well. So to begin with, we're going to start in the financial realm. Some less restrictive options for people who maybe just need some assistance in managing their money outside of guardian of estate would be to get a representative payee, which is issued through the Social Security office. Basically, an authorized rep. If an individual needs help managing their Social Security income, it's going to be determined through Social Security office whether or not they need the authorized rep. But an authorized rep can be established, or a rep payee can be established, sorry. An authorized rep is designed to help them manage their other benefits, whether it be railroad retirement, Black lung benefits, VA, Medicaid renewals, food stamps, Section 8. There's all kinds of other benefits that an authorized rep can be put in place to help with as well. Trusts are another way that can help protect an individual's finances. There's a couple different paths you can take here. Trusts are a great way to handle if an individual is getting, an inheritance or money from an estate settlement or a lawsuit settlement or anything like that. If they're coming into an influx of money, putting money into a trust is a great way to protect it. The key is when you're looking at trusts, you want to make sure that you're looking at Medicaid protected trusts, not just any type of trust. If you put them in just one of the various types of trusts out there, but it's not Medicaid protected, then Medicaid and them can come after those funds as assets and claim it. But if it's a Medicaid protected trust, then the money's off limits and the individual can spend it for what they need it for. Medicaid protected trusts do have some limitations on what the money can be spent for. Generally, you can't spend the money from the trust on things that would normally be paid for by either Social Security or Medicaid. That would be like rent, some utilities, and that kind of stuff, but it will pay for an individual's vacation. It'll pay for a new sofa. It'll pay for, internet or cable, because that's a luxury utility, not a necessity. There's a whole variety of things that you can use that money for, though. I would strongly say, if you're looking at setting up a trust for your loved one, research all your options. I would talk to someone who's an expertise in these areas. There's a variety of trust management firms out there you can talk to. There are a number of attorneys who specialize in special needs trusts. That'd be a great asset for you to talk to. Here at APSI, we have a number of individuals that do have trusts, but I don't set them up for them. As guardian of person, we don't have any authority in that capacity. But I do know a lot of people out there, so I'm happy to connect you with players and people who may be able to help provide more information on that front. Back in 2014, the federal government passed the ABLE Act, which stands for Achieving a Better Life Experience. What this did is it allowed for individuals with disabilities to basically begin saving and investing money without losing eligibility to programs like Medicaid or SSI. It's really a great program. It kind of acts as kind of like a glorified banking account, and it's protected from, being claimed as an asset, which is great. There are limits to the amount of money you can invest each year. And there is I want to say, and roughly it's about $16,000 a year you can invest. There is an end limit at the max you can save, but it's in the six figures. So for most individuals, that's not going to be an issue. But the nice thing also is that anybody who supports the individual, their family members, their friends, if they want to contribute to that person's stable account, they can. And it's really kind of a great program. Now, stable accounts are typically have to be signed up and signed for by a guardian. It gets real tricky if you're a guardian of person, because you technically don't have the authority to establish one for an individual. But the probate court can grant you special, one-time, ability to set one up for an individual. We have seen that occur on many occasions. I threw conservatorship in here. You're going to hear the term conservatorship in a variety of ways. Conservatorship is very much just like guardianship. It's just different terminology. Across the U.S., in certain states, you're not going to hear the term guardian. You're going to hear the term conservatorship. They're pretty much very similarly one and the same. It's basically where an individual has been determined that they need help managing certain aspects of their lives. For anybody that's been following the news, the big conservatorship that's been in the news here lately has been Britney Spears' conservatorship, and that's made all kinds of media attention. So, but basically what that is essentially a guardianship. Protection orders. Wanted to bring this up because sometimes there's questions about how to keep an individual maybe from having contact with another individual where there's been a long history of issues. So there are a couple different type of protection orders that can be pursued. There's civil protection order, which can be put in place for up to 5 years. There's temporary protection orders as well that can be issued by a criminal court judge if there's any kind of criminal component to it. One thing I would say with protection orders is they have their time and place, and they can be really effective for certain situations. But before you go and talk about your loved one, about entering into a protection order of any capacity, I would really strongly think, is my loved one going to violate that protection order? If your loved one is likely to violate that protection order themselves, I would think twice about having one put in place, because if your individual violates it, they themselves can be held criminally liable for violating the protection order that they themselves had put in place for their own protection. So it's a little bit of a catch-22 sometimes. A lot of times the individuals that I hear discussions about protection orders being put in place are the individuals that are going to violate it. They're going to go and see that person regardless of the protection order being put in place.
Kristina, there's a question, I think, going back to your stable,
Yeah.
your stable account trust, I believe is, Mary, I think that's what you were referring to. If you set up the account, can you manage it also for them? Correct me if I'm not catching the right account, Mary, but I think
Sure.
that's what
Yeah,
she's
the
referring
stable
to.
account. Yep. So stable account. So yes, I usually strongly encourage, if there's a rep payee, let them manage it for your individual. If you are the rep payee, then there you go. But yes, it is possible for you to still manage it. If you are a guardian of your loved one and you're setting one up, I would just make sure when you approach the court about the right to do it, that you also just clarify that you also will be managing it on their behalf. The probate court may ask for you to file an annual filing of it, just so that they can see that it's, occurring and everything's good. They may not. Each probate court would probably handle that situation very differently. I can tell you that they all would, based on my own personal experience. Every court and every judge kind of has a different interpretation of what they want to know. I can see Darke County really wanting to know that, and I can see Hamilton County saying, I have too much to do already, and I don't need that on my plate as well. So each court kind of has a different personality to them and what they might want as far as information on that front.
Did that answer your question, Mary?
It did.
Okay.
Great. Power of attorney. I talked about this a little bit ago when I was talking about the difference between guardian of estate and the difference in power of attorney. So just kind of rehash this a little bit for everyone. A power of attorney is basically a legal document that gives someone the authority to act on another person's behalf. In order to enter into a power of attorney contract, the person must be competent and have the capacity to enter into that legal appointment. Power of attorneys can be revoked at any time by the person who initiated it. I would definitely say they are a great asset for individuals who maybe don't need full guardianship, but where someone might need the ability to help jump in from time to time to help guide the individual or provide an informed consent in a situation where the individual just really doesn't have the capacity to do so. You will also find oftentimes just saying you have a power of attorney for someone, doctors will talk to you, and a variety of other people will talk to you about your loved one, even though technically they probably shouldn't if your loved one still has the capacity in that moment. But it kind of becomes this like legal gray area for HIPAA, is what I've noticed. So power of attorneys are definitely a great resource. It's definitely a less restrictive option than guardianship. The individual still retains all their rights to make all the decisions they want, but allows you to help them navigate some of the complexities with them. If you're thinking about setting up a power of attorney, basically, if your loved one's thinking about setting up a power of attorney, make sure that they have been informed of their rights, that they trust the person they're appointing, because if I'm setting up a power of attorney and I hand that right over to someone else and they don't do what is in what I've asked my interest to be represented as, then it can create a really nasty situation. If you are a loved one entering into a power of attorney on behalf of your loved one, I definitely would ask what their interests and what their wants and what their wishes are, so you can best represent them. It's very similar to guardianship. You want to get their input and their desires and their thoughts on matters so you can represent it the best possible. Same kind of concept with power of attorney. Adult Protective Services for DD or the elderly. This is a little known clause that exists in Ohio Revised Code, and if anyone's from county boards on this call, I apologize in advance. They hate that I even mentioned this. But a court can order a county board to provide protective services for up to 1 year for an adult with a developmental or intellectual disability. And I know mental retardation is listed in this slide. Again, this is straight terminology from the court themselves and the Ohio Revised Code ruling. But basically, it's really set up for anybody who has been a victim of abuse or neglect and really lacks the capacity to protect themselves from those situations. The court can order the county board to render protective services. What that looks like is varies. It can be emergency removal placements. It can be that the county board themselves acts as kind of a pseudo guardian for that individual until the court determines a clear path. I have seen this play out on a couple different occasions. I can tell you every county board out there right now is cringing at the thought of being the pseudo guardian for anyone. And those that have done it will tell you, do not get involved if you can avoid it. But the thing is, it is still a less restrictive option to guardianship that's time limited, that is an option out there. Adult Protective Services for the elderly is kind of similar, except it's not DD. It would be Jobs and Family Services that would be appointed, and it is for anyone over the age of 60. And again, it is for very significant situations: physical, sexual, emotional, financial abuse, or neglect of someone 60 or older. There are a number of other community resources out there that can be used for specific situations. One of them is an ombudsman. If you have an individual who resides in a long-term care facility, which is probably not so much on this call, given that most of the people are 22 and under that we're talking about here, but you can't rule that out because medical needs vary from person to person, and there is a possibility that someone in that age range might be in a long-term care facility or a nursing home. An ombudsman can be that advocate and that voice for an individual to make sure that they're getting the services they need, that they can work through any kind of problems or conflicts that are occurring between the individual, their family, or their guardian, and the long-term care provider. And they also can link everyone to additional resources that exist here in Ohio for their loved one. And then supported decision-making is probably the newest option to a less restrictive option to guardianship. Basically what this is the individual themselves gets to make their own decisions. There's no guardian in place. What they do is they've designated someone that they trust to help them understand information so they can make their own decisions. Initially, it really only applied within the DD system when this rolled out. It's since begun to expand into multiple systems outside just DD. One aspect, though, is you really cannot have a financial interest in the matter if you're going to be that support decision makers person that they've designated. And one thing to know is support decision making is different for everyone. I think everyone on this call has used some form of support decision making in their life at some point in time. I know I have, where I had no idea what doctors were telling me about, and I had to go do research or talk to a family member who'd been through a similar experience to get their thoughts on the matter. It's a very similar type of aspect. You gather information from those you trust or that can help you maybe interpret it in a way that you weren't looking or understanding, so that you can make the decision that's right for you. There's a number of ways to execute a support decision-making contract. You can do it through a formal power of attorney type setting. You can do it through the ISP process. There is no wrong way or right way to do it. It really is a person-centered driven approach. There is a link on this PowerPoint, and Patty, correct me if I'm wrong. Are you going to share my PowerPoint with everybody?
Yes, correct. We'll, at the end, we'll share a link to our SALT Google Drive and the live binder, and everything is in there.
Perfect. So I'm not going to pull this link up now because it's an hour and a half long, and obviously we do not have an hour and a half. But there is an attorney by the name of Jonathan Martinez who really has brought this poor decision making to the forefront. He is really great at explaining it, far better than I have. I have had the opportunity to meet him in person and talk with him at length one-on-one about poor decision making over the years. But I did put a link to one of his YouTube presentations he did. So anybody that's interested in like how this might roll out, and really good examples of how it's rolled out for various people across the US, I would strongly encourage you to look at that YouTube video, or even just Google Jonathan Martinez and look up some of his other videos as well. I did break down a little bit about the difference between supported decision-making and less restrictive options versus guardianship, to kind of help you kind of understand the differences a little bit. Who makes the decision? And under guardianship, it is the guardian who makes the final decision. Under supported decision-making, it's the individual who ultimately makes the final decision for themselves. What is the role of the court? Under guardianship, everything goes through the court. All changes of appointment, moves, everything, it goes through the court process. Supported decision-making, the court's not even involved. So they can change the person who they've designated as their supporter at any time, at any time without having to go through the court. They can add additional people as their support team that can help them make those decisions or understand the decisions that they're making without having to go through the court at all. What are the protections against abuse? So guardianship, technically the court is the one that oversees the relationship, but unless there's a complaint made to the court about something going on in the guardianship case, or a real significant MUI that brings a situation to the court's attention, the court rarely intervenes in guardianship cases. Under supported decision making, there's likely going to be multiple supporters. It might be a family member or a family friend. If there's additional supports and services in place, like county board SSAs, individuals can appoint multiple supporters, and if they do, it kind of creates a natural check and balance. And because they're so active in the day-to-day life of the individual, it kind of really creates an instantaneous checks and balance, which is a little bit different than guardianship. And how are the person's needs assessed? So under guardianship, their needs are assessed through an expert evaluation, which may look at individuals' diagnoses, their IQ score, and just doctors' recommendations on what their needs are. Under supported decision-making, it's done through a natural discussion. It's done through the team process to determine, what kind of skills do they have? Have they learned from the skills they were working on? Can we, are they becoming more and more independent, or do they still need help in this area? And if so, great. Maybe the supported decision-making agreement that's entered into gets changed to address that. So there's definitely a very clear difference between less restrictive versus more restrictive, but there's a place for both. There are individuals out there who supported decision-making or less restrictive options are just not going to meet the individual's needs. And then there's individuals who are currently under guardianship that maybe don't need the level of guardianship anymore and can be looking at a less restrictive path like supported decision-making. And that's something that I know at APSI we're constantly assessing with our own clients. I did go ahead and also on this PowerPoint list out a variety of resources out there. Obviously, our website's there. I also listed the National Guardianship Association and the Ohio Guardianship Association's websites. They both have standards of practice for guardianship and good recommendations on how to navigate difficulties you might face as a guardian on those websites. I have DOD's website there. I have Disability Rights Ohio. I have OPRA, which is the Ohio Provider Resource Association, and I also have the ARC of Ohio's website there. There's a lot more resources out there, but these are some really good starting points, and big entities that have a lot of resources and references on their websites that I think are great. Any questions?
I do. I want to go back to the about the marriage, and you said with the new rule 66. So if there were two individuals, both with guardians, that want to get married, and both guardians are you know, saying, okay, this is okay, but they don't realize that this can be done, you know, that I mean, I will tell you, I work with a lot of parents who are under the assumption that that is not allowed. What would be the process?
Sure. I think each process is going to be slightly different, but how I would approach it if it was two of my clients, you know, talking about getting married, there's a whole bunch that goes into this decision. So I think, you know, the guardians should sit down with their respective loved ones, or do it as a big team process, depending on what kind of supports they have. But I think they need to sit down and discuss a number of things. If you get married, your resources join. They may end up losing, you know, eligibility to Medicaid and other benefits they naturally qualify for as a single person. But the minute you get married, your income doubles, and as a result, you may lose benefits. So it may be worth having the team ask for a benefits analysis from the county board to see how it would impact if the individuals did get married. What kind of resources would they lose? How would it impact their service needs? And then educate the individuals as such. You know, help them understand that if they do this, this is how their life will be impacted, besides just being married. You know, sometimes we've had individuals elect, after finding out a lot of this information, to just have commitment ceremonies instead of an actual legal marriage, so that they can live together and act like husband and wife, or, you know, wife and wife, or husband and husband, depending on your sexual orientation. But you can still act like you're married without actually legally being married and jeopardizing your benefits. If it's something that the benefits are not going to be impacted greatly, then I still think it's worth having a sit-down discussion. I know I would be encouraging my individuals to maybe talk with a relationship therapist, just so they can work through any things that maybe the individuals themselves have not thought through. I know I have several individuals who want to get married, and they view it as the adult thing to do without realizing that there is a lot that goes into being married. And so having a professional that can actually be the one to talk them through those things, versus it being you as mom or dad, or, you know, the guardian, or, you know, the natural support being the bad guy. Let someone else be the one to educate them. Bring in those outside resources to help. And then ultimately, if everyone is in agreement that this can or should be pursued and anything like that, then I would, you know, send a letter or a motion to the probate court and ask for a status hearing and bring it before the court. One thing to know is your individuals have the right at any point in time to ask for a status hearing with the court. It is up to the court if they elect to grant that hearing, but the individuals themselves could bring this matter to the court anyways, even outside of you. Now, you as guardian would definitely have a platform at the court to say, I have concerns and this is why. But it's very possible that that can occur too. I've had that happen on our end, or the individual themselves ask for the status hearing of the court so they can discuss, you know, potential marriages. But I think it's very much individually driven based on the needs of the two people that are discussing marriage. There are individuals I serve that very much could have the capacity and understanding of what might go into a marriage, and then I have individuals who truly do not. So I think it really is going to be dictated. But I would definitely use outside resources like therapists, relationship counselors to help educate. I would definitely make sure individuals are educated on their resource benefit options and how it might impact them if they get married, including potentially even losing their Medicaid waiver services, and placement and housing and Section 8 and food stamps, and all those things could be impacted by someone getting married.
There is
Great.
another question
Very
here.
much.
Oh, sorry. Did that answer your question, Kathy?
Yes, it did. I thank you very much for expanding on that.
Yeah.
I just saw there was another question out here. Very good question. How easy is it to undo a guardianship? For example, if the ward needs, for example, if the ward needs a guardian at the age of 18, but with enough maturity and time, maybe become more independent and guardianship may not be necessary, and the guardianship alternatives may be more appropriate.
Great question. So that's something at APSI we're currently working through. We have we've been working through individuals we've been guardianship for a long time and how to restore them to competency. And that's what that's called, is restoration to competency. So if you have a loved one who you're guardian of, and over the years you've really worked with them to gain independence, to gain skills, to be able to become more independent in their decision-making capacity, and you don't feel they need a guardian anymore, then what you're going to want to do is maybe get an updated assessment, a psychological assessment or an expert eval that reflects that the individual may not need a full guardian. Maybe you can step it down to medical only, or maybe then you can stage it from medical to full restoration. It is something that I think as a guardian you should always be striving for, as long as the individual themselves has that capacity to grow and learn and adapt and all that kind of stuff. We have successor restoration cases at APSI yearly. We really work to try to restore individuals when possible. I will be honest, some probate courts are very open to restorations and truly understand what that means. There are other courts that really struggle in understanding what restorations are, and it may take a little bit of an education on that front to get a magistrate or a judge to understand what you're asking. But it's something I think as a guardian it's our obligation to always be seeking those less restrictive options when possible. I know there's been times at APSI and cases where we wanted to give the individual that independence as much as possible, but the court wasn't ready to remove us. So we built it into the IP, those independent levels, and we sent the IP to the court so they knew what areas we were giving the individual control over. And the court then signed off on agreeing with us trying that with the individual. There's all kinds of paths you can take to promote that independence and that less restrictive option. But yes, restoration to competency is what that's called, and there is a path forward for that.
It looks like that's all the questions that were typed in the chat. I do want to, we'll stop the recording and just kind of open it up for those who may want to just speak directly without typing. There is one. Is there an IQ that the court looks at? There is another question there.
So there's, in order to establish guardianship, there has to be what's called an expert evaluation filled out by a doctor. It can be a primary care, it can be a psychologist, it can be a psychiatrist. Anyone who has gone through med school and is a licensed doctor can sign off on the expert eval. The expert evaluation has not necessarily IQs, but they have the ranges of mild, moderate, severe to profound intellectual disabilities as options to check on that form. So it's not just a straight IQ. And I do very much find that a straight IQ is not going to give you an honest assessment on an individual's needs. I have individuals that sometimes have a lower IQ, but they're very capable of managing a lot of things on their own. And I have individuals who have, a very high IQ, and you're going, how can you not do this? So very much, I think IQ is kind of an arbitrary number, but the form itself does not ask about IQs. It just asks what category of intellectual disability you might fall within.
Did that answer your question okay, Sue? So, oh, there we go. Here's another question. 1 second. When is the best time to apply for guardianship if your child is 17 years old and severely disabled mentally and physically?
Okay, great question. You legally can't even apply until they turn 18. Adult probate court is 18 and older. So you couldn't file prior to their 18th. The court wouldn't even process the application. So 18 is the earliest you can do. However, you can begin that prep work. I would encourage people to begin getting that application ready, getting that expert evaluation ready at probably 2 months prior to their 18th birthday. So on their 18th birthday, you can go and drop that right off at the probate court and say, here you go, and get a hearing set so you can begin that process.
Great questions tonight, I tell you, a lot of good questions. So I'll go ahead and have Michelle post the links to our SALT Google Drive and our live binder. That's where I uploaded all the mention of the handouts tonight, and it'll take a few days, but the recording from tonight will be in there also, so you can reference it at a later time. I know how time goes, and it's like, oh, maybe you weren't going through it at that time, but in a few months you're going through guardianship. But I wanted to make sure that we have the recording out there so you guys can go back and reference it, as well as the presentation information. I'm going to launch real quick while I'm talking another poll, just the end of a session poll, just a survey. Go ahead. I can't talk and launch things. So, I mean, feel free to answer that. I wanted to launch the poll, just the end of the session survey, because we do have a survey that pops up in your browser following the session. Sometimes people see it and sometimes they don't. So I just wanted to make sure everyone got a chance to complete it that wanted to. The survey that pops up in after the meeting's over in the browser will give you a chance to ask any questions following the session, like if there's something that you want us to follow up with, whether associated with this topic or session or another one. So that's what's on that one. It pops up in the browser. I want to thank everybody for coming tonight. I'm going to go ahead and close down the recording here and open it up for those who are still on and want to ask Kristina maybe just some questions without typing, or just verbally ask them. So let me close that down, but thank everybody for coming tonight, and for Kristina for the wonderful, it was a great presentation. So thank you.